Okay, now. Is that working? I think I'm working now. Working now. Okay, good. Stupid fucking computers. Ugh, I hate computers. Computers hate me back with equal veracity. We are on the same wavelength of hatred. Here we go. Okay, thank you, Factual Lies. Sorry about that. All right. So, what I was saying is we are going to talk about the UHC Killer, who I'm calling the UHC Hottie. Okay. He, as I was saying, I guess I was muted. I'm a fan of Josh Johnson and his stand-up, and he did a fantastic stand-up recap of the Young Thug trial. So if you followed me on the Young Thug trial and you haven't yet seen that Josh Johnson stand-up, I highly recommend it. So go check that out. But what happened was the Johnson did a stand-up on the UHC shooter, and he did this whole thing on how every shot this kid is in, no matter what, even still shots of video, he looks handsome. He looks good. I mean, look at this. Look at that. Is that not a face? Morning Tall Glass. Okay, Factual Lie said he or she watched the stand-up, right? It is hilarious. And Josh Johnson's like, no matter what, if it's like a screenshot or, whatever, he looks handsome. Josh Johnson nailed it. I mean, it's true. This kid he's a very good-looking young man. It's surprising. Like, well, yeah, it is surprising, actually. Kid comes from money. Okay, so kid comes from money. I don't necessarily understand why he chose UHC's CEO. I know the kid had some back surgeries and stuff, but he never even had United Healthcare. Look at this. Even Josh Johnson's like, I mean, look at this. Even his mugshot. He looks good. He's this handsome, cute-looking dude. Hi, Shazza. Okay, so what we know. Allegedly, this young man shot the UHC CEO, who is not a sympathetic victim. I'm not a very sympathetic victim when I'm victimized because I'm kind of a bitch. But I've never actually been the root cause of thousands of people dying. I'm just kind of bitchy, that's all. Okay, so I don't know necessarily why he chose the UHC CEO, but I do know this. The UHC CEO, hold on, was charged with insider trading, or he was accused of insider trading. Now, I don't know if little Luigi knew that. Here's another thing. Every other CEO in America has nice looking teeth, but this guy can't because the company he works for refuses to cover your teeth. So if he had nice teeth, I'd be really pissed. So Brian Thompson, who, in this shot is killed, allegedly, this is Luigi. Allegedly. We don't know. So he was gunned down in Manhattan. But it looks like he was accused of fraud and insider trading in a lawsuit earlier this year. As if it's not bad enough that you're the CEO of the number one denier of coverage. Health insurance costs outpacing inflation, guys. Look at this. This is inflation. Here's healthcare. It's crazy. And healthcare has oh no, I'm sorry, this is inflation. The dark green is inflation. This is healthcare. Now, prior to Obamacare, when you turned 18, you had to go learn what healthcare was, what coverages were, and what you needed. And you found out that if you're a woman, you pay more because you might get pregnant. That's what I got to learn when I turned 18. But then thanks to Obamacare, I now have my son on my insurance until he's 26. Thanks, Obama. So UHC is charging the living shit out of people. They are beating inflation on their rates. And they are the number one denier of claims out of all the major health plans. Hold on. All right, right here, December 5th, the Boston Globe. Oh, come on, they won't let me in. They want me to pay. Why? Why can't we have free information? Okay, let's see. Maybe I can get it free here. All right. Right here, 32%. That's twice the industry average. Now, I do some work in my business with United Healthcare, and I find them to be wonderful to work with. And when these things we do are negotiations, they have always been very positive to patient. I had United Healthcare back when I worked for a large corporation, and I thought the coverage was fantastic. I thought they were great. It's really expensive. That's why I have Blue Cross Blue Shield now, who it turns out prior to this shooting would not have paid for my anesthesia all the way through an entire surgery. Like, get what? So I'm gonna be cut open on the table. Like, Miss Cadillac, do you have enough money to continue the anesthesia and the surgery? What? Okay. Blue Cross Blue Shield immediately backtracked on that when this shooting happened. Why? Because they had to. Because they were afraid their CEO might got shot. In 2024, the average health insurance premium for families carried a price tag of $25,000 per year, while single workers paid an average of $8,951. $10,000 a person a year. And then don't forget the $7,000 deductible. Don't forget that I then have to pay another $10 million to even gain access to the coverage. Okay, so now Luigi, the UHC, I mean, just the cutest little... Look at this guy. You guys, look at this. Look at this. Dude's in jail. He looks adorable. Like, who is going to put this man behind bars? Who is going to see a victim who is denying 32% of claims? I mean, I could say, like, almost everyone personally knows someone who has passed away because they could not get medication, because they couldn't afford it. Who has debt? I heard something like 20% of American household debt is medical. Right? So where are you going to find 12 jurors? Back up. First, kid got charged in Pennsylvania. He's, eating at a McDonald's. But then he was extradited to New York City. With new charges. Oh, and this is crazy. When he shows up in New York City, the mayor is there. And Mayor Adams is there to like walk. I mean, what? Eric Adams. And here's the other thing. And Josh Jackson, or Josh Johnson, like made jokes about this, and I've heard other comedians. How many people are shot and killed in New York every day? Actually, let me ask Google. How many people are killed by gunshots in NYC each year? Okay, here's a monthly shooting activity report. Okay. Rochester. Oh, I don't know what counties there. I don't know. These are not the cities that I'm looking for. These are not the cities you are looking for. Okay, so people get shot a lot in New York City, right? Like, maybe not in the morning. Like, in the middle of the morning, maybe. But people get shot in New York all the time. And then people flee New York, and then they're brought back to New York. And you know who doesn't show up? The mayor. Okay, Shazza, yes. So it's the same Eric Adams, the same mayor. And I don't think they fired him. Indictment. He was indicted. But you know, felons are allowed to run shit now, so nobody cares. Nobody cares anymore. Okay, over here. This is in September. Eric Adams was charged with bribery and campaign finance offenses. And basically what he did is he flew to like Turkey and some other places. And instead of flying in normal regular class, he took upgrades to business and first class, which are worth, I don't know, $20,000 or something. I don't know. It's ridiculous. I don't know how a seat on the same plane can cost $15,000 for, I mean, it's ridiculous, but whatever. So anyhow, he took these upgraded flights. And that's basically, he did accept illegal campaign contributions. Okay, well, I didn't hear about that part, but he took these flight upgrades, and I guess that was illegal. I don't understand why he needed to be in Turkey, to begin with, but okay. So Shazza, to your point, he is indicted, but he has not been found guilty, and he is still the mayor. Okay? So, Luigi yesterday woke up in Pennsylvania. Last night went to sleep in the same jail as Diddy. So he woke up in Pennsylvania and he went to sleep in the same jail as in the Diddy jail. Okay. Oh, okay. During his New York hearing, he sat between his two lawyers, Karen Friedman Agnifilo, and her husband, Mark Agnifilo, who is also representing Diddy. Interesting. I mean, the kid does come from money, so it makes sense that he would have like a very expensive lawyer. Apparently, okay, so he's had several charges, and that's the interesting thing. So the charges themselves, murder, obviously. Now that one makes sense, right? That's clear as day. But then he was charged with stalking. And, okay, let's see. He's charged with one count of using a firearm to commit murder. Fine. One count of interstate stalking resulting in death. So there's a show right now on Netflix called I'm a Stalker. And they defined stalking in Indiana And I don't think Luigi's behavior amounted, at least to Indiana law, to stalking. But I think my understanding is that Luigi had sent some kind of letter or threat, and so maybe that's why they're saying stalking. One count of stalking through use of interstate facilities, and one count of discharging a firearm that was equipped with a silencer in furtherance of a crime. And that's it. I swear he was charged with some kind of terroristic something. Which Belinda and I are like, besides the CEOs of healthcare companies, who did this guy terrorize? You guys got to watch Josh Johnson's stand-up on it. It's so funny. He's talking about the cops searching in Central Park, and he's like, oh, well, he's not in this bush, and can't really think of where else to look. I mean, it's hilarious. Okay, it's so classic. It's wonderful. Here's the thing. This kid is charged with all these multiple crimes. Fine. Here is the issue. Where are you going to find? Where in the world are you going to find? Well, not in the world. Where in the United States of America are you going to find 12 human beings that don't have a strong bias against health insurance? Where are you going to find 12 humans over the age of 18 in the United States that do not have some kind of bias against health insurance companies? Guesses, anyone? Anyone have any guesses? Are there 12 people living under rocks? I don't know. It is going to be so hard. That was one of the first things I thought of when I saw who the victim was. I'm like, this is not a sympathetic victim. This is not the kind of victim that the jury is going to cry for. Okay? And it's gonna be really hard to find 12 people. Shaza says some people can acknowledge their bias and be objective anyway. Sure. But where are you gonna find 12 of those people? You're not. You're not. You are not going to find 12 people. I mean, good luck. You're going to have a bench trial. And, you know, he is not going to want a bench trial. He has a right to have a jury. That's going to be really, that's going to be really, really hard. Okay, so that is a lovely segue into our next update, which is on Diddy. Diddy was in court this week, I guess like 2 days ago. And this is... So Diddy is in federal court. They don't have cameras. They still have court sketch artists, all right? Y'all, this is how the sketch artist interpreted Diddy. This is how the sketch artist interpreted Diddy. He's gray. He is gray. So they were saying that in this trial, in this hearing, he came in that he is like gray in color, like almost jaundiced in a way. Hey Jiggy, happy Friday to you. Hi Alicia, Regina, everyone that's here. Thank you so much for being here. It's good to see you all this morning. I appreciate it. All right, y'all. So this is Blizz said, "Oh, that courtroom artist did Diddy dirty." Shazza says they should sketch a long crime logo on it. It's fair. Belen says they did Diddy dirty. This is my understanding. Like, several people reported that he looked gray in color. So bizarre. This hearing was a very basic hearing. It was not like, hey, can he get out? It was basically like, we'll have this information to you by this day. We'll have this to you, So by the 31st, 11 days from now, the government has committed to having, well, first, they said that this is still an open investigation. Okay, so there's that. It's still an open investigation. And what that means is that the government is likely to prosecute more people. I believe we're going to see an updated indictment, a superseding indictment, and I believe we are going to see some of those employees of Diddy's enterprise. I think we're going to start seeing them named. That's my guess. Okay. Diddy himself is set for trial. They are going to be starting on Cinco de Mayo, which happens to be Belin's birthday. So that's very exciting. Cinco de Mayo. He's going to trial, y'all. And it's not going to be good. Apparently, 2 of his sons were at this hearing. Another one of his sons is running into trouble. A lot of his kids are kind of giving up hope on him, I guess. I'm not sure, but it is not looking good for Diddy. The real question in my mind is Diddy going to start naming names to begin to maybe try to lessen his punishment, right? Like, is he going to start pointing at people to try to get a lesser punishment? Like, oh, look, I'm cooperating. You know, so that'll be interesting. It'll be interesting to see if we start seeing names. Obviously, we saw Jay-Z last week. So, that will be very, very interesting to me. Hi, Anya. How you doing? Okay. Got a couple little updates on YSL. We had, hold on, before we get to that. I don't know if y'all saw this, but Lil Durk, do you, yes, Shaza, Diddy will play the Woody card, yes. Okay, so I don't know if y'all saw this, but as you all know, Lil Durk got arrested in like a, was it murder for hire? And he bought 3 airplane tickets, 2 on commercial airlines and 1 private jet, and then he got arrested. Okay, so he's been arrested and they're doing their investigation. He's in jail. All this stuff is going on. And now Lil Durk has been implicated in a second murder for hire. This one in Chicago. So that's going to be interesting too. It turns out now maybe Lil Durk has a pattern of paying people to do his dirty work. Very interesting news coming out of there. So I will certainly be keeping everyone abreast of that, okay? Okay, so now let's go to YSL. Shannon and Yak were in trial.
Today, right in position 3, it lists Attorney Bumpus. Is that?
I should be the attorney of record of all 3.
I thought so, but I'm just, it was a misunderstanding.
And that's fine. And I appreciate
Y'all, I had missed this man. I really had. You know, like it was really weird going without Shard, without all these characters that we have been watching like every day for years, and now we're not seeing them anymore. So it was nice to see him back in a courtroom. This is a different judge. I don't know her name. This is regarding Shannon Stillwell, whose real name is Shannon Jackson, but he was indicted as Stillwell. Who knows why? Oh, I do, because Fulton County's full of useless idiots. Anyhow, he picked up charges while he was in jail because he was in jail for 2 years for no fucking reason. So here we go.
Court making time for us, Your Honor. We will have a negotiated plea to present to the court this morning.
Hold on 1 second. I need to get the ADA on the record.
Morning, Your Honor. Chris Derry, out of the state of judicial efficiency. I'll handle all three matters.
All right, thank you.
And, Your Honor, I do believe that I need to sign some indictments in preparation of the plea. Do we have those in court?
Yes. Good morning,
Okay.
Mr. Jackson.
Familiar
As
faces.
you stand before me today, you are here on 3 indictments. Indictment 22 SC 181814, Indictment 22 SC 185532, Indictment 23 SC 188183. My understanding in consultation with the state and your attorney is that we have a global resolution to all 3 cases. Is that correct?
That is correct, Your Honor.
All right, you're going to be entering a plea of guilty to certain charges in these 3 indictments. So if you will, we raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
I need for you to tell me your name and spell it, please.
Shannon Jackson, SHANNON, JACKSON.
Okay, put your hand down. Now, Mr. Jackson, the state has a series of questions to ask you. If you can, answer yes or no. If you need an explanation before giving an answer, let the court know and we will provide you with an explanation. If you need to speak to your attorney before giving an answer, let the court know and we will give you an opportunity to speak to your attorney. Do you understand?
Yes, ma'am.
All right, thank you. The state may proceed.
Thank you, Your Honor. Mr. Jackson, at this time, are you under the influence of any alcohol, drugs, or medicine that would negatively impact your ability to understand today's proceedings?
No, sir.
And how old are you?
32.
What's the farthest level of education that you've gone?
9.
Can you read, write, understand the English language?
Yes, sir.
And you're a little soft-spoken. Do you mind speaking up a little bit for Madam Court Reporter? All right. Now, do you understand that you were charged in case number 22 SC 181814 with possession of a Schedule 5 controlled substance, possession of a firearm during commission of a felony, possession of a firearm by convicted felon?
Yes, sir.
You understand the maximum possible punishment on the possession of a Schedule 5 is up to 3 years in confinement?
Yes, sir.
You understand the maximum possible punishment on possession of a firearm during commission of a felony is up to 5 years, which would have to run consecutive?
Yes, sir.
You understand the maximum possible punishment on possession of a firearm by convicted felon is up to 10 years in confinement?
Yes, sir.
Now, you're also charged in resolving today case number 22 SC 185532, in which you were charged in count 1 with serious injury by vehicle, count 2 entering auto with intent to commit a felony, count 3 theft by taking, count 4 failure to maintain insurance. Do you understand that as to count 1, the serious injury by vehicle, you could be sentenced up to 10 years in confinement?
Yes, sir.
Do you understand that for the entering auto, the maximum possible punishment for which you could be sentenced is up to 5 years in confinement?
Yes, sir.
And do you understand that for the theft by taking, based upon what the amount alleged in the indictment, that being greater than $5,000, less than $25,000, the maximum possible punishment for that offense could be up to 10 years in confinement?
Yes, sir.
And do you understand that count 4, the failure to maintain insurance is a misdemeanor punishable by up to 12 months in confinement?
Yes, sir.
Now, as to case number 23 SC 188183, you were charged in counts 1 and 2 with participation in criminal street gang activity, count 3 possession of methamphetamine with intent to distribute, and counts 4 through 8 with possession of prohibited.
Oh, whoa, 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 whoa. Did you hear that? Did you? Methamphetamine? He had possession of methamphetamine with intent to distribute?
Items by injury. Do you understand that for those counts 1 and 2, the gang activity, you could be sentenced up to 20 years in confinement?
Yes, sir.
Do you understand for the possession of methamphetamine with intent to distribute, you could be sentenced up to 30 years in confinement?
Yes, sir.
And do you understand the maximum possible punishment for each of those possession of prohibited items by inmate is up to 5 years in confinement?
Yes, sir.
Now, do you understand that you have the right to plead either guilty or not guilty to any and all of these offenses? And if you pled not guilty, you would have the right to a jury trial in which the state would have to prove your guilt beyond a reasonable doubt.
Yes, sir.
Now, as your attorney, going over with you this form that I'm holding, plea of guilty, acknowledgement, waiver of rights.
Yes, sir. I remember.
All this is boilerplate. All this
And you
has
have
to
an
be
opportunity to review
said.
this form, go over this form in its entirety, and do you understand this form?
Yes, sir.
Now, Mr. Sharp, are you waiving any potential defects in this indictment on behalf of your client, as well as formal reading of the indictment?
So wait to both.
And Mr. Jackson, do you need any more time with Mr. Sharp? Are you prepared to move forward at this time?
No, sir.
Now, in relation to this particular case, I believe you've been arrested on all of these offenses. Do you understand that if you enter this plea, that this also can be used in the future? It's what we call recidivist punishment, which means that if you got in trouble down the road, a court could look and see these convictions.
Okay, so like all of this language that's going on right now that the state is saying, all of this is being said by the state because case law requires the state to say this. Somewhere along the line, some lawyer did not warn some person that, you know, if they plead guilty, then they might not be able to get a job because they're a felon. So that person then went and, you know, appealed and went up and up and up. And so then the court came out and said, well, you need to warn people about that. And boom, this is how you have your warning. You know, on TV when they say, like, you have the right to remain silent and blah, 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 right? Those are your Miranda rights. And that whole little, those 2 paragraphs came out of case law. Miranda v. Arizona, 1964. So all of this, like, blah, 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 this is boilerplate. It has to be said. He has to affirm or deny, yes or no that he has it, because the Supreme Court said they have to. Now, I can't tell you, oh, that's Supreme Court of U.S., that's Supreme Court of Georgia that's requiring those. I don't know that detail, but I know that this exists because it has to. This boring part.
And therefore go ahead and censure to something greater than it normally would. Do you understand that?
Yes, sir.
You also understand there can be what we call collateral consequences to this plea. What I mean by that is that this can have a negative impact on, say, your ability to vote, your ability to have gainful employment, things of that nature.
Yes, sir.
Mr. Jackson, are you a United States citizen?
Yes, sir.
And you understand this is a negotiated plea of guilty,
Yes,
which means that your attorney and I in the state have come to a global resolution. We're going to go ahead and propose that to the court, and the court can choose to accept or reject that. However, if the court chooses to reject it, it could sentence you to something greater than what is negotiated. Do you understand that?
Yes, sir.
Now, this would not have to comply with all of those terms of probation, which also include not possessing a firearm.
Yes, sir.
You also understand that possession of a firearm, aside from a probation violation, also would act as a new offense as you are convicted felon.
Yes, sir.
Now, do you also understand that there can be, do you understand that you're waiving any and all defenses, including any mental health defenses, by entering into this plea of guilty?
Yes, sir.
Now, do you understand? I'm going to read off a list of rights here. At the end, I'm going to ask if you understand you're waiving all of those rights, okay?
All right.
Do you understand?
Okay, again, like, this whole list is like somewhere, some way along the way between the birth of the United States and today, these went to court, and the court said, yeah, we got to do this, we got to do this. And so then what happens is the prosecutors just add that, to their, like, script. And he's just reading off a script. I hate, you guys know I hate checklists in court. This is not a checklist in court. You have to have the checklist, right? Okay. Before I continue, a couple things real quick. First of all, thank you for being here. I really appreciate it. I am Lauren Cadillac, aka OG Cadillac, aka Mother of the Decade, aka your favorite lawyer on the internet. Thank you for being here. I appreciate it. We are demonetized, so if you want to support the channel, we would greatly appreciate it. You must use Cashapp lcadilac. All right? So thank you all. Thank you for being here. Hi, Raynette. Hi, Demetrius. Sorry I was muted there for a second. I don't know what happened. Oh, I do. I had a cough, so I muted it, and then I guess I didn't unmute properly. All right, back to the boilerplate.
And by entering this plea, some have the charges against these are in fact guilty. However, brief, you understand you can enter a plea of no contest as to the participation in criminal street gang counts, which is 1 and 2.
Yes, sir.
You understand you'd also be entering a plea on Alpha v. North Carolina in counts 3 through 8, which is the possession of methamphetamine with intent to distribute and the possession of prohibited items.
Yes, sir.
Now, do you understand as to case number 22 SC 1-2, that being serious injury by vehicle, entering auto with intent to commit theft, which are the no contest as well as the offer?
Yes, sir.
All right, understanding all of that, how do you wish to enter your plea?
Guilty.
That be guilty as to on the 22 SC, the serious injury by vehicle, the entering auto with intent to commit felony, theft by taking and failure to maintain insurance, is that guilty?
Yes.
As to the 22 SC 181814, which is the possession of 5 controlled substances, is that guilty?
Yes.
And then as to 23 SC 188183, counts 1 and 2, of participation in criminal street gang, what is your verdict, or what is your plea?
No contest.
And the counts 3, possession of methamphetamine with intent to distribute, and then the counts 4 through 8, the possession of prohibited items by an inmate. What is your plea?
Guilty on the Alpha.
And is that plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand you would have only a limited right to appeal this guilty plea conviction?
Yes, sir.
And do you understand that for the felonies, you would have up to 4 years from today's date is to file what we call habeas corpus, and that's if you want to challenge the constitutionality of 12 months from today's date to also file the habeas. Judge, I will begin with the serious injury by vehicle case, which is the 22 SC 185532. Had this case proceeded to trial, the evidence would show that on June 7th of 2021, law enforcement responded to a motor vehicle accident on I-85 at Metropolitan Parkway, that location being inside of Fulton County. Judge, it was determined that this defendant was the at-fault driver in a motor vehicle collision that did result in the victim sustaining a fractured arm. Judge, there was a bystander that attempted to render assistance. Mr. Jackson then did leave from the scene in that bystander's vehicle without permission, that vehicle being greater than $5,000 but less than $20,000 in value. Judge, the defendant also did not have valid insurance at the time of the motor vehicle collision, nor the...
Y'all. He got in an accident and then stole the vehicle of someone who stopped to help.
Departure from the scene. Judge, as to case number 22 SC 181814, had the case proceeded to trial, the state would show that on October 27th of 2020, law enforcement with Atlanta Police Department responded to an address on Judy Lane, which is located inside of Fulton County. They responded to that location because the defendant was parked inside of a driveway where he did not reside. Upon approach, law enforcement observed what appeared to be a prescription bottle. Judge, a canine came around and possibly tested, possibly alerted as to contraband inside of the vehicle. The defendant was a convicted felon at the time. Law enforcement was able to locate a loaded firearm inside of that vehicle, Judge, in addition to locating promethazine, which was the Schedule 5 controlled substance. And Judge, finally, as to case number 23 SC 188183, while the defendant was at the Rice Street Jail located inside of Fulton County on March 29th of 2023, law enforcement conducted a search inside of his cell. Judge, that was a shared cell, and located inside of that cell included a cell phone, the pills that tested positive for methamphetamine. Judge, the quantity would be consistent with the intent to distribute, as well as a shank, which is often used in either self-defense or to be the initial aggressor or primary aggressor, depending upon what day it is at Rice Street. And Judge, possession of Apple AirPods and an iPhone as well. Judge, I'll begin with what the negotiated recommendation is on case number 22 SC 185532. That's the serious injury by vehicle. Judge, the state's recommendation on count 1 is 10 years to serve 3 years. However, that 3 years is commuted to time served. Count 2, the entering auto with intent to commit a felony, is 5 years probated to run consecutive to count 1. Count 3, theft by taking, is 5 years probation to run concurrent with count 1. And count 4, the failure to maintain insurance, is 12 months confinement commuted to time served. Judge, as to case 22 SC 181814, possession of a controlled substance, that judge recommendation is 3 years commuted to time served. As to count 2, that would have to run consecutive to count 3. So count 3 would be 10 years probation, and count 2 would be 5 years probation to run consecutive, for a total of 15 years probation.
I believe my understanding of the recommendation was that was going to be 10, the count 2 was going to be 10 to serve 3 commuted to time served balance on probation,
Yes.
as opposed to 10 years probation.
I will defer to you as you were the one actively involved in negotiations on this one, Mr. Sharp.
Okay, so if you just go over those again for the record, for
Okay.
count, for 22 SC 181814. Count 1.
Is possession of controlled substance, that would be 3 years commuted to time served. Count 2 would be 10 to do 3 commuted to.
You can't do that if you're going to do count 3, because count 2, possession of a firearm during commission of a felony, is a mandatory consecutive. So you would have to have count 3, the possession of a firearm, at some period of time, so statute minimum of 1.
Okay.
So
I don't have the indictment in front of me. I think what I meant to say is count 3. Count 3 would be 10 to do 3 commuted to time served, balance probated, and count 2 would be 5 years probation consecutive.
Correct.
The difference, Your Honor, is him essentially receiving a sentence of 12 years probation versus 15 years probation. The intent is it would be 12 years probation because he's already served those 3 years.
All right, so let's be clear. Count 3. 10 to serve 3 commuted to time served balance on probation. Count 2. 5 years probation consecutive to count 3.
That's right. Yes,
And count 1. 3 years to serve commuted to time served.
Correct, Your Honor.
Yes, Your Honor.
You may continue.
Okay, Shazza, that is a great question. So, again, along with all that boilerplate information that they have to say because case law tells them you have to say it, case law requires that the prosecution on the record, before explaining the terms that they've negotiated of the plea, the prosecution explain on the record what they believe they would have proven in trial. So that's what you just heard. He's reading it as if it's a fact, because he's saying this is what we would have shown you in trial. Whether or not that's true is, obviously we're never going to know because there's not going to be a trial. However, case law requires that they put that out there. So that's what you were hearing and seeing.
As to case number 23 SC 188183, as to counts 1 through 8, they all would be a concurrent 5 years to serve 2 years, if the 2 years commuted upon time served. Judge, there are specific conditions that would go with these cases. Specifically, Judge, there was a negotiated from the trial division for a banishment from Metro Atlanta area as a condition of this sentence. He is to maintain gainful employment while on probation. There would be no contact or communication, either directly or indirectly, with any named co-defendant in the case number 22 SC 183572. There's to be no contact or communication directly or indirectly with any persons associated or affiliated with a criminal street gang, and there's to be no possession of a firearm on his person in any vehicle in which he occupies nor any residence. Quite frankly, just no possession of a firearm, given he would be a convicted felon. Judge, I also understand, and Mr. Sharp had approached me about concerns about being able to travel through the Atlanta airport. There would be no objection to an exception for the Atlanta airport. Judge, this is the only case that was assigned to my unit, and I believe it actually was initially with the high-profile unit, was the gang case. And so, Judge, I do want to clarify for future cases why I am consenting to a no contest on counts 1 and 2, as it's not something I typically do, as this court's aware. Judge, the reasons for that is taking into account the working relationship I've had with Mr. Sharp over the years, who reached out to me along with Ms. Bumpus to try to resolve this case. Judge, understanding that there is multiple cases here, so I did not want to run into a situation where Mr. Jackson, who's had some incidents, unfortunately, at the jail, was remaining in jail while we litigated whether or not we were going to be dealing with a no contest on this case. And that is because also in this particular case, the typical negatives of a no contest plea for the prosecution are not present. Specifically because he is already a C recidivist, this is irrelevant, frankly, whether or not we will be able to have three convictions in the future. Judge, understanding as well that the negotiated terms of a larger sentence include provisions of no criminal street gang activity, as well as the negotiation of banishment. Judge, I believe that is a fair trade-off in taking into consideration the banishment provision. And Judge, from a factual basis as to this particular case, Judge, we are running into a situation, had this proceeded to trial, that this was in fact a shared cell. Judge, it's been in the past occasions where other individuals' contraband can in fact be found in other individual cells, as well as the fact that there was a shared cell, so there's other individuals that would have had access. And Judge, in this particular case, I have not been made aware of any cellular dump in this particular case. Had a cellular dump been done in this case, and I have been provided with that, that would have demonstrated possession or control or intent over the narcotics or objects inside of that cell, we probably would be in a different situation. But I'm not going to hold Mr. Jackson at Rice Street or ask him to be held at Rice Street while we did a cellular dump in order to ascertain that we have a resolution that appears to be amicable to all parties. So just for future no contest cases, I want to be able to distinguish Mr. Jackson from other defendants that maybe argue were similarly situated.
All right, thank you. So will you go over the...
Okay, so basically, let me translate that. I'm not a piece of shit, and so I don't want this man to have to sit in jail and rot when maybe he shouldn't be in jail. I know there's a lot of words, but that's really what he just said, okay? Really what he just said is, I don't want to be a piece of shit. So I'm going to let this man out while we do the negotiating. I know Mr. Shard, and Mr. Shard has convinced me that I don't want to be a total piece of shit like Adrian Love.
The special conditions again on...
Mr. Jackson is 32 years of age. His father is present here in court. His father works an honest job for an honest living. His wife is also present in court supporting him. He has 4 children. And so a lot of these past acts involve selfishness, immaturity, and I believe that Mr. Jackson, throughout this whole legal process, has come to realize how valuable life is and you only get one. And I think he wants to make everyone proud, all the supporters proud, and people that have been here for him proud. So I know that he knows that he has people in his corner, and we're hoping, if Your Honor accepts this plea, we're hoping that this is something that we can all look back upon and say that this had a happy ending.
All right, so I have a couple of questions regarding the banishment. It's my understanding that he's from the metropolitan Atlanta area.
He is. Your Honor.
Okay.
He's lived here his entire life.
All right. So are there special circumstances under which he would be allowed to return during the period he's banished? Did the state negotiate?
Judge, again, that was a negotiated term outside of the one. I understand there are going to be times in which this court would make exceptions, such as coming back for funerals or weddings. I understand this court traditionally does not do banishment outside of accepted negotiated terms. So to the extent this court is setting exceptions, I would defer to this court.
Your Honor, I anticipate that at some point in the future there'll be a need to return back to Atlanta. I'm not trying to violate any agreements that I have with the state. The way I thought, quite honestly, the way I envisioned this happening was if there was a specific need, Mr. Jackson would reach out to me, and then I would reach out to Mr. Sperry. I know that creates more work for all of us, but I thought that would probably be the best workaround at this time, and quite frankly, in the future, if things are going well on probation, then maybe we can revisit some of these conditions.
All right. Yes, but you have to tell us who you are for the record.
Hi, Judge Jones, Officer Jones with probation DCS. Due to the fact that where he's going, if they do not accept his case, we will have to come back in front of the judge to modify the sentence. I don't know that right now, and I won't know that until 7 days from today. I have spoken with my AC, so I am trying to get the situation expedited, but he won't go to the probation until Thursday.
All right, thank you.
What? Okay. I don't.
So essentially what she's saying is until the state that you are moving to accepts your probation, you will be here in Atlanta, and everybody knows that, somewhere in the metropolitan Atlanta area.
Okay.
Okay?
Okay, so he is moving
As
to Texas.
Indictment 23 SC 188183, Indictment 22 SC 181814, Indictment 22 SC 185532. The court is going to find that the defendant has entered a pleas that were willingly, knowingly, freely, and voluntarily given, and that there is a factual basis for each plea, be it no contest or an Alfred plea or just a regular guilty plea. All right? So we're going to start with 3-2. The negotiated and recommended sentence is on count 1, the defendant is to be sentenced to 10 years to serve 3 commuted to time served. Count 2, 5 years probated to serve consecutive to count 1. Count 3, 5 years probation to run concurrent to count 1. 12 months on count 4 commuted to time served. Count indictment 22 SC 181814. Count 3, 10 to serve 3 commuted to time served. Count 2, 5 years probation concurrent to count 3. Count 1, 3 years to serve commuted to time served. Indictment 23 SC 188183. On all 8 counts, 5 years to serve 2 commuted to time served, balance on probation to run concurrent with 22 SC 185532, count 1.
Okay.
And also in 22 SC 181814, the sentences are to run concurrent to count 1 in 22 SC 185532. During the time of your probation, you are to maintain gainful employment. You are to have no contact with any co-defendant in 22 SC 183572. I don't want to assume, is he not related to any of those co-defendants?
Sure.
All right, okay. So the people who used to be your friends or the ones that say you used to be associated with, you can't have any contact with them. That means you don't respond to emails, texts, smoke signals, shout outs, Instagram, whatever. They're no longer people that you can have any contact with, because if you have contact with them, you run the risk of being violated on your probation and you end up in the Georgia prison system. And from my understanding, that's not the place you want to be. I understand that you were assaulted while you were at the Fulton County Jail, and unfortunately, that's no place anybody wants to be either. So the best lesson for everyone here is to stay out of the criminal justice system. At one point, when I was a judge on the Fulton County Juvenile Court bench, 88% of the people in the Georgia prison system did not have a high school diploma. So what that tells you is the best way to stay out of prison is to get a high school diploma. So you indicated you dropped out at 9th grade. You need to go back and
I don't think that's how logic works, but okay.
get a GED so you can move forward in life. If someone wants to give you an opportunity, you can step up and take it, because you can check the box that I have a GED or a high school diploma. It is basically a weeding out process and basically indicates to an employer that you know how to show up and do assignments in a timely manner. That's all they're looking for. You will show up, do the assignment in a timely manner, and not cause any problems, because you've shown you can do that because you've matriculated through high school. So they just want to know you're not going to be a problem, and they don't have to worry about you. And more importantly, the court didn't want to have to look back and say, I just should have sent you to jail, as opposed to going along with this negotiated plea. You're getting a second opportunity. I suggest you take full advantage of it. You're 32 years old. I can say to you, based on what I've seen, the next time you get a felony conviction, you're going to be looking at a lot of years, and nobody's going to say yes to probation under any circumstances. So
She's right about that. I mean, she's definitely right about that. She is giving him a big chance. There's no doubt.
the banishment will be for 5 years because they didn't negotiate a term. So that's for 5 years, and you can come back for special occasions, and the state and your attorney can work out what those occasions are. But you cannot come back unless you have been approved to do so, and notice has been given to the state and they've signed off on it. You are to not to have any firearm in your possession because you're a convicted felon, and you're not to engage in any street gang, criminal street gang activity. I assume that you know all of the co-defendants in 22 SC 183572, so you know the people that you're not to have any contact with. I always make this an issue with the state because I don't want to assume that the defendant knows these individuals.
He does not know all the individuals, but he knows who they are from going through the case.
So I would suggest that the state provides him a list of all the individuals, their known names and their street names, and any other AKAs they have out there, so there's no misunderstanding.
Good.
Okay? And your family members need to know that although you can have communication with them, they should not be carrying messages from any of these people that you're not to have any activity with. So, did I miss anything?
Your Honor, just one thing. If we could put on the sentencing sheet that all these sentences are to run concurrent with the sentence that Mr. Jackson has from 22 SC 183572.
Any objection from the state?
No objection.
Okay, so all the sentences from 22 SC 181814, 22 SC 185532, 23 SC 188183 are to run concurrent with 22 SC 183572.
That Max Shard, that is some lawyer, y'all. That
At
man.
this time, does probation need to come on record and say anything? Oh,
Just tell you will report on December 19th.
so, Don't be late. Don't miss that appointment because they will come back to court and ask me to issue a warrant for you failing to appear. Do you understand?
Yes, ma'am.
All right. So at this time, is there anything else from either party?
Just as Mr. Sharp had recommended, I have no intention of leaving my office anytime soon, at least voluntarily. So Mr. Sharp and I have built up a point of trust and communication over the years. I have no problem with Mr. Sharp reaching out to me if there's any exceptions that are necessary. That's great.
And also for the record, I will waive fines and fees for these 3 cases since he's already on probation in another case.
Thank you.
All right.
Oh,
If
very
there's nothing
nice.
further, then all parties are excused.
Thank you, Your Honor.
Very nice. I tell you, that Maxwell Shard.
Business after probation is done for me, may I excuse?
Yes.
See you tomorrow.
All right.
Position 7 on the final plea calendar.
Hold on.
That Max Shard, man, that is a good lawyer right there. That is a good lawyer. All right, so now we have Yak.
It's 24 SC 004460 and 23 SC 188186. Both of these are State versus Kendrick. Hello, Mr. Kendrick. I'm all right. How are you doing?
Okay, there he is.
I'm Judge McBurney, and we are going to work through bond in your 2 cases. You've got 1 case that's assigned to me.
He's with Kayla.
Charged with aggravated battery, aggravated assault, and riot. You've got a whole bunch of co-defendants in that case. And you have an older case that is assigned to Judge Whitaker, in which you are charged with having an iPhone and AirPods while you were in the county jail. Ms. Bumpus represents you. Ms. Bumpus, are you representing Mr. Kendrick for bond only or through the duration of these 2 cases?
Through the duration, Your Honor.
Excellent. So Ms. Bumpus is here for the whole ride, and then Mr. Rao is representing the state. But like I said, all we're doing today is talking about bond. So I'm going to turn it over to Ms. Bumpus, hear from her about why you're a good candidate for bond in these 2 cases and what that bond should look like. And then I'll hear from Mr. Rao, and then you'll hear from me when you're ready.
Good morning, Your Honor.
Good morning.
And if you don't mind, I'm going to condense both the cases into one argument.
That's fine.
Okay. I'm just going to keep it short and sweet. As this honorable court, I'm pretty sure knows, Mr. Kendrick has been in custody since May 9th, 2022. He has since been found not guilty on the charges that initially had him in custody. During those 2.5 years, he picked up these additional jail cases. The first case was picked up, as you stated, in April of 2023, the second in June of 2024. It is my understanding that Mr. Kendrick has 3 previous felony convictions, none of them being violent convictions. That is my understanding. And as we know, that is one of the factors in this court considering the bond. The second factor I'd like to address, which is extremely important to me, is community ties. And this is important to me as an attorney because Mr. Kendrick has family support. He has a lot of support. And not only are they here today, but they have been in court with him almost every day for the past 2.5 years. And I think that shows that he has a support system standing behind him. And he has a lot of accountability and responsibility to do the right thing if he's given the opportunity to give him a bond. This is a jail incident, Your Honor. And, you know, I come before you a lot. And it's very sad to say, but normally when I pick up a client who I can't get a bond for immediately, that's a double client because they're going to get a jail case. It's almost inevitable. And especially when you have been sitting in jail for 2.5 years for something that you essentially are found not guilty for. And had he not been there, this would not have happened. He has no reason, I don't even think he has an ability to contact the victim in this case if he is granted the opportunity to give him a bond. Also, I would like to talk about the aggravated assault, aggravated battery, and riot charges. I did not represent Mr. Kendrick, and he did not have an opportunity to sit in the preliminary hearing on this case, but there was a preliminary hearing held on this case.
When you say he wasn't able to sit in, he was in through Zoom,
No,
or
he was in trial, but the co-defendants were.
oh, okay, so there was a prelim not as to him personally and directly because he was in 1C,
Yes, Judge.
but in 2B, 1 floor up, they went forward with some or most of the other defendants.
Yes, Judge.
Okay.
And in that case, it's my understanding that the judge decided that there was the facts did not arise to an aggravated assault, but a battery. And I know that, you know, the state can then go and indict it and do what they do, but I just wanted the court to know that. In the bond motion that I filed, I specifically stated the DOJ report that was issued in November of 2024. This is extremely concerning for me because my client knows this all too well because he was actually a victim of a stabbing on December 1st. And you are very familiar with how it goes when people are close to release and when people are in high profile cases, and there is a target on his back. And, you know, I'm not sure, but there are also some people who may not be very happy with the not guilty verdict in this case and what he has alleged to have been a part of, but found not guilty of. I don't believe Mr. Kendrick has any history of FTAs. I have watched him fight for his life for 2.5 years, and I can only imagine the resources it took to afford an attorney, to afford clothes, to afford everything that he had to do, but he still found a way to afford me, which means he takes this case serious, even though it's a jail case, which means me and him are going to work together to make sure he's back at every court date and do what we have to do so that he can follow any conditions given by this court. Considering the fact of everything, I'm asking the court to set a bond no higher than $20,000 on all the counts.
Talk to me about where Mr. Kendrick would stay. I don't mean a specific address, but with whom, what that setting would be, and what kind of work he would be able to do if he's going to be working when he gets out. And I know some of those are strange questions because he's been in for 2.5 years, so it's not like there's a job at this firm where he was working. Hey, we held your spot for 2.5 years, but I trust you and he have discussed something about the structure that would be in place, and that would help me understand what Mr. Kendrick would be up to and not up to should he be released.
Your Honor, Mr. Kendrick was a recording artist and is a recording artist, and not just, our typical, I'm a rapper, but a real one. And it's...
Kayla's not the best lawyer, y'all. She's newer, I think. She's practicing. I don't think she speaks in a fluent manner for a courtroom, but I think she's getting there. She just needs some practice.
As soon as he's released, I believe he's going to start back making music. And before this, and I have pictures ready to present if the court wants to see, but I'm an officer of the court. But he was coaching Little League, he was performing, he was being a valuable member of society until arrested for charges that he was found not guilty of 2 years later, as he sat in the Fulton County Jail. I do have an address, and I did speak with his mother this morning that I can provide off the record.
Sure.
And it is a complicated situation because he's been in custody, but they have been working hard since I filed this motion to find somewhere for him to go.
He would stay with his mother, or he would stay at this address that his mother was able to find for him?
At this address that his mother would, and that's something, if you don't mind, we can talk about off the record just because of the whole situation.
No, I don't mind, and I'm trying to be elliptical about it, but it's probably wise for Mr. Kendrick, while he's on bond for these 2 cases, that it not be a house that's shared by people with whom he allegedly associated in the underlying case. And so while if he does make bond, I encourage him to pursue whatever trade, and that could be music and whatnot, it's going to need to be in a thoughtful way where he is not bumping up against some folks that he might have in the past circulated with for all sorts of good reasons or bad reasons, but that landed him in the trial that lasted 2 years and kept him in custody for 2 years. And I don't think it's an unreasonable expectation to say, while you're on bond for 2 other matters, you're going to need to move in a different way and in different circles than you did before. And so that's the only reason why I'm asking. It's not for you to share publicly. It'll be 123 Main Street, and I'll be staying with this person. But those people need to not be people with whom he associated before, not because that's necessarily a forever condition, but if he is going to be on bond for these things, I think everyone needs a comfort level, and basically for his own safety, you're not going back to whatever life was before. And so I need to be comfortable that those guardrails are in place. So it may be, and I'll hear from Mr. Rao in a minute, that we need to have some email back and forth about what those conditions would look like, who can be around Mr. Kendrick, who he needs to not be around. And something as simple as you can't go to those studios, because those studios are ones where we read about them and it's a great music making place, and the next day there's a dead guy in the parking lot. And that has nothing to do with Mr. Kendrick, but he can't be in that kind of space. He needs to find a studio up on a mountain.
Well, Your Honor, I think that we're going to be working on getting a studio in wherever he resides so that he can, take some time. He's been in the public eye for 2 years, so I think he wants to take some time to make some music and gather himself.
Okay. All right. I don't want to get ahead of maybe that bond's not appropriate, but I wanted you to know that if I do set a bond, we may need to have some exchanges, including the state, about what's that going to look like structurally, so that I know what I can put in the bond that's not sealed, because there'll be a bond order that says here you go, but there may be certain things that are under seal for a good reason. So we can work through that. But your request is a $20,000 bond across the 2 cases.
Yes, Judge.
Okay. All right. I appreciate that. Let me see. I want to try again, Ms. Jackson. I don't have any reason to believe they fixed the technical difficulties, but could you pop your mic on and say hi?
Hi, can you hear me, Your Honor?
Okay, yeah, it didn't work again. It's not on your end. It's something happening here, because everyone...
Okay, so I think Kayla, she made a really good point, but I don't think she made it clearly enough. Yak was found innocent. Okay, he was, all charges dropped. The jury said, nah, he didn't do it. The government did not prove their case. He only picked up these new charges because the government wouldn't give him bond and had him in the jailhouse. But he's innocent for that crime. So if he had been treated, maybe how he should have been treated by getting bail, then this crime would have never happened. She tried to articulate that. I just don't think she did a very great job at it.
Who is not in court to hear what you're saying. I'll ask Mr. Rao about criminal history, but if the tech folks show up in time to fix it, that would be great. I'll look at what's in the chat. Okay. Thank you, Officer Evans. Mr. Kendrick has a warrant from PCS, so that complicates things as well. But let me hear your presentation, and then I'll get the warrant out to everyone.
Yes, Judge. The defendant stands before you having been indicted on 2 separate cases, which opposing counsel presented to the court. The aggravated assault, aggravated battery occurred on June 17th of this year, where the defendant is alleged to have been the main perpetrator amongst 7 co-defendants who've also been indicted, to my understanding, performing essentially a vicious beating and assault on a fellow inmate, Detrell Wembley, causing severe lashes to his back by using electrical cords to essentially whip the victim in that particular case, causing bruises both to his back, neck, as well as his face.
So I'm a little familiar with that case because there's a co-defendant, Mr. Thomas, who had a very, very old murder. You know the history of that. It's a lot of co-defendants, and I'm wondering if you are able at this juncture to dissect that case enough to say, and we're particularly concerned because Mr. Kendrick had a lead role versus he held the door open with his foot, because my understanding, just from hearing a little bit from Mr. Thomas's co-defendant, Thomas's lawyers, is that not all, they weren't acknowledging that anything happened, but that not all of the co-defendants were equally situated. And I think that has an impact on how to think through what bond would look like.
That's correct, Judge. And I think that's an accurate statement that not all defendants were similarly situated. What is clear from the Fulton County Sheriff's Office's investigation is that the defendant is the main perpetrator behind the assault on the victim in this particular case.
Okay, so basically the judge was like, hey, I have another guy who's part of that gang that did the beating. And my understanding is, you know, some people were really involved. Some people were just kind of watching loosely, you know, whatever. And if they were watching loosely, that's different than if they're the ones who actually assaulted the guy. And so then the prosecutor says, yes, I agree. But Yak was the leader, and he was the head part of the assault. Yes, Shaza, I think Kalis did not present clearly enough that sentiment. She tried to put it out there. She kind of put it out there. I just don't think she asserted it clear enough. Okay. Another CG. Yeah, they're in jail, so they don't need iPods, and they don't need cell phones. They don't need TV. You know, Sheriff Joe Arpaio used to only give them bologna sandwiches and cartoons or something. And I'm with that. If I ran a jail, you would get 24-hour news. And it'd be C-SPAN. It'd be boring ass shit, okay? You're in jail. You don't get iPods. You don't get iPhones. You don't get... come on. You're incarcerated. Now, these men are incarcerated and they're innocent and awaiting trial. But still. I mean, when I found out that there's a whole hashtag on TikTok of jail, prisoners of TikTok and stuff, that pissed me off. So jail isn't even bad anymore? Jail is fun now? Like, come on. Jail is not a deterrent if we don't make it boring. Now, should it have holes in the walls and people attacking each other and rats and lice killing people? No, absolutely no. But should you be in a clean cell and pretty bored? Yes, that is yes.
Between 7:55 p.m. On the night of June 16th up until 8 a.m. the following morning is when the assault is alleged to have occurred. And the reason why they're able to provide that time frame is because in that surveillance video that they observed, Mr. Kendrick appears to be the main perpetrator going into the cell where the victim was, and he remained there the entire time. And by he, I mean the victim. The victim remained there.
Got it. Let me pause you for 1 second.
Because that doesn't make sense to me. So the video, the victim goes in and remains there the whole time. So how is Mr. Kendrick the instigator? What is the evidence of instigation? Oh.
Let's try Officer Evans. Officer Evans, can you...
Yes, Your Honor.
Look at that. It's better. Thank you so much. Thank you, Mr.
Yes, Your
Kendrick.
Honor.
All right. Somehow that device's volume got turned down, but we're back. All right. So your perspective from a review of the evidence is that Mr. Kendrick would have been the lead, if you will, on the assault. I'm going to call it the assault case.
That's correct. And in addition to that, the had an opportunity to speak with Mr. Kendrick. And essentially, there's a lot of commotion in the background because it's on a body camera footage. They were able to secure a statement from Mr. Kendrick and
Mr. Kendrick or from Mr. Wimberly?
Both. But
okay.
With respect to Mr. Kendrick, it's essentially he's saying, "What else am I going to do? It's about respect. They're stealing my stuff. I got to do something." So I would disagree with the assertions that this is just a battery, and I think I'm more than happy to share the photographs with the court, and the court can make that judgment as well. But we are respectfully asking, in conclusion, that the court deny bond in both cases. I will recite to the court the defendant's criminal history. He does, in fact, have 3 prior convictions, one out of Maricopa County, for which he was convicted for theft by shoplifting and possession of drug paraphernalia on April 9th, 2015. The defendant then subsequently secured a conviction for felon in possession of a firearm. This appears to be a federal case that was prosecuted by the Northern District of Georgia, from my understanding of the NCIC and GCIC.
Okay, this pisses me off, but we'll get into that in 1 second. Locking people in boxes doesn't do much of anything. I agree. Should we give them TikTok? Absolutely the fuck not. Should we give them the Bible? Sure, Brooklyn, let's give them the Bible. Let's give them other books. Let's have some therapists. Let's do group therapy. Let's make jail look more like rehab. Because we want to be honest, and we should be honest, the majority of the people in jail are doing drugs. Drugs somehow got them there, right? Like, you know, drugs, alcohol, whatever it is. So you should be able to come out rehabilitated. Not on TikTok, not brainwashed, rehabilitated. Let's have classes. Let's have job skills. Let's have, let's talk about sobriety. There should be. And Shazza, they should pay for it. Okay? Like, the point, sadly, because our jails, just like everything else in America, America is a corporation, all right? We're the United Corporation of America, right? Our jails are corporations, they're for profit. It's the goal of the government to have people in the system and stay in the system. They want to keep them in the system, and that way the government can control them and make money off them and basically use them as slaves, okay? So that is the government's goal. That goal needs to be undone. The goal of putting people in jail should be, it is not currently, but it should be to work on healing. You should go to jail to think about what you did and figure out how you won't do it again. That's what timeout is for. My kids are in timeout. You go to timeout, you think about what you did. Think about what you did and how you're not going to do it again. That's it. That is what jail should be. Hold on. Let me go.
For which he was sentenced.
Well, I think we pay something like $32,000 per prisoner per year. Hold on. Oh my God. $30,000 to $47,000 we're paying every year for someone in prison. All right. You're getting $16,000 per year on a public school. Okay. No. Jail should be safe, tall glass. I agree. Absolutely. The jail should be timeout, and timeout takes more than one day. You can't just say, oh, gee, yeah, I did something bad. No, you have to, go figure out why and how to never do it again. Okay, so look at this. Currently, in the United States, we're spending an average of $16,280 per year on students and twice that on prisoners. So we already have the budget. Come on. The system should be about help, not keeping people in the system. The system should be about curing and fixing and helping, not oppressing and keeping. Okay. Yeah, I know, Brooklyn. Most people come out worse than when they went in. They put kids in there, and they call that the college of criminals. You know, you get a master's degree in crime. It's ridiculous. Would someone call it justice if we rehabilitated people? I think so. Yeah. I truly think they would. Yeah, I do. Oh, okay. You did some terrible fucked up shit, and then you went to jail and you worked on yourself and you healed, and now you don't do terrible fucked up shit. Yeah, that's justice. I think that's great. Yeah. I think that is, yeah, that's what we do with our children. right? Like, we don't forever punish our children, or at least we shouldn't. No, towards a mom, I would say the healthcare system is more evil than the prison system. And the reason why is because there are more people in the healthcare system than the prison system. Okay, here we go. All right.
February 22nd, 2017, and I do see at least a probation violation on 2020. There wasn't any further information as to...
Okay, so this really irks me. In 2015, he's in Maricopa County, which is Phoenix, Arizona area, picks up some charges, and then 2 years later, those same charges, he gets hit with them again in federal court. Same charge. Is that not double jeopardy, y'all? Like, what the fuck?
Why, whether it was a technical or substantive violation. Then, on August 28, 2017, the defendant was convicted in a Fulton County Superior Court case, indictment number 15 SC 140116, and was convicted of 6 charges: conspiracy to commit aggravated assault, participation in criminal street gang activity, theft by receiving, violation of the Georgia Controlled Substance Act, fleeing and attempting to elude, and possession of a firearm by convicted felon. In that particular case, the defendant was found to be in possession of a .40 caliber Smith & Wesson handgun, as well as an AK-47 in a vehicle, where he and his co-defendant in that particular case were on their way to a rival gang member's territory to commit a retaliation assault based on some prior actions. And that is the statement of Mr. Kendrick himself to law enforcement during the investigation of that particular case.
Can you give me that case number again, please?
Yes, Your Honor. 15 SC, the remaining last 5 years being suspended. In addition to that, Judge, we believe the defendant is a risk to reoffend based on his criminal history. We believe he's a danger to the community based on the fact that when he was arrested on May 9th, 2022, in between May 9th, 2022 and this date, the defendant has at least 13 reported jail incidents while in the custody of the Fulton County Sheriff's Office. Of those 13 incidents...
this pisses me off, too. He's been in jail for 2 years. He only has 13 incidents. I feel like I would get 13 incidents in one day if I was in jail. Like, I'm a dick, okay? Like, 13 in 2 years seems really good. That's not even one a month. It's like one every 2 months.
10 are allegations of violence, and 3 are allegations of possession of contraband.
Whatever.
And those include the indicted cases before the court today, which the defense is seeking a bond hearing. In many of those cases, there are other witnesses that came forward, including the most recent one on December 1st, 2024, where the allegations that the defendant was stabbed. Well, he was stabbed, and according to what another witness said, both a correction officer and an inmate, because the defendant went up to the inmate and started assaulting him. And I guess from the inmate's perspective, he needed to defend himself. Not that I agree that he should have been in possession of a weapon in the jail, but those are the allegations that have been put forth in this particular case. In every single one of those acts, violent incidents that the jail has reported, the defendant, through investigation as well as testimony or statements from other inmates, have pointed him to being the perpetrator of the assault. And so, while I certainly understand everyone's talking about the conditions of the jail, Exhibit A is before you as to why it's unsafe. So, Judge, we're respectfully asking the court to deny bond.
I'm sorry, if he's beating people up in jail, wouldn't it be better to take him out of jail? Are you taking away his potential victims if he's no longer in the jailhouse? I don't know.
We believe that the defendant is a danger to the community, a risk to reoffend, and a potential risk of flight given the circumstances of his arrest on May 9th, 2022, when he fled the scene after a search warrant was executed on the residence where the defendant was at the time.
Do you have any visibility into whether your office is going to be bringing other cases from these other incidents? And I ask not to press or speed anything, but more so for management, frankly. I mean, Ms. Bumpus needs to know what she and her client are up against, and I know that your office assault or
with that, make a determination. With respect to the other ones, without committing anything to the court, I don't believe we'll be going forward on any of those.
Okay, so they would be at most, if Mr. Kendrick would go to trial, could be 404B or could be linked to one of these other situations, or it would be something in aggravation, a bond hearing or a sentencing hearing. Is your best forecast with maybe one exception?
That's correct.
Okay. All right. Thank you. Thank you. Ms. Bumpus, I want to give you the last word. I'm going to not be able to rule immediately because I need to look into the probation situation that was just brought to all of our attention. And certainly want to understand that before I do something on this.
Yes, Judge. And it is my understanding that the allegation of the likelihood of reoffending, I just want to revisit that because the last time that my client committed a crime was in 2015, 10 years ago. And, well, minus these jail cases.
Right. I don't know the federal one. It sounds like that was resolved in 2017, but that doesn't mean it wasn't 2014 conduct.
Your Honor, it's the feds picked up this state case, so they're not two separate crimes.
Okay.
This 2015 is the federal case.
All right. So they just was dual sovereigns, and Mr. Kendrick got squeezed in both places.
Yes, Judge. So not two separate.
That's such bullshit. That is such bullshit. How does that even work?
Separate acts. And me saying that, I don't know if this brings any or can help us get clarity on the warrant, because my client's understanding is that the federal probation then trumped the state probation, and he was to be reporting to federal probation because they had taken over this case.
Well, I don't think legally it would be that the state probation goes away. There's supervised release. That's what they call it on the federal side. It may well be that Mr. Kendrick had a very clear understanding with DCS, state probation. Hey, you report to those federal folks. But that doesn't mean there wasn't a probation clock ticking and running throughout. And so what's been brought to my attention is that there may be a probation warrant situation as a result of these two cases. So as
Max Sharp just got up.
Kendrick, everything's all connected. And so it may be deemed a violation of his state probation from the 2015 case that he got mixed up with having contraband and was allegedly part of the assault on Mr. Wimber. And you know, that's how it flows. And so if that warrant is out there, then we need to work through that, and setting a bond doesn't make a lot of sense until that warrant is addressed. You know full well, once that warrant is addressed, or if it's lifted, or it's dismissed, or I don't know, the judges tend to set bond on probation warrants, but if so, then we don't need to reconvene this session. I'll know that that warrant's out of the way, and then it does make sense to think about what a bond would look like for Mr. Kendrick for the two cases.
Here's what I don't understand. Dude's been in jail for 2.5 years, and you're just now seeing the warrant? Like, that doesn't, I mean, it makes sense because I deal with the government, and I know that they don't, like, communicate with each other, but it doesn't make sense.
For which you represent him. If there is a warrant, that will just be a little additional time that you can work with Mr. Rao to figure out, is there going to be a third matter, or is this our universe, the assault case and the contraband case?
Okay, Your Honor, and just in closing, I just wanted to reiterate for the record that those two, the federal case and the state case, are one occurrence.
Okay.
And that the additional alleged acts in the jail, I mean, he has not been charged.
Understood. And my inquiries of Mr. Rao were more, as you heard them, which is, is there more coming that we need to be waiting for? Because it's, fair is the wrong word, but sort of from a due process perspective, Mr. Kendrick's entitled to say, can we wrap all this up? And it may be 3 accusations and 2 indictments, but whatever the state's going to do, don't do it piecemeal 3 months later, then 3 months later, and then 3 months later, for things that have already allegedly occurred. Now, if tomorrow something happens, that's a new vista for the state. But what Mr. Rao was referring to with the 13 incidents and the contraband, that's already happened. And so I can't force the state to say, here's your cutoff, and you need to decide what you're going to deal with. But it doesn't help anyone to just keep bringing you and Mr. Kendrick back. Like, all right, this time it was a cell phone, this time it was a cheeseburger. Let's just wrap it all up if that's what's going to happen. And I trust Mr. Rao's going to look into that, and they typically don't get every cheeseburger case. You get written up at the jail, but then as you hear about it, that's when someone says, oh, he was a saint when he was in jail. And they said, well, not so much. He was a saint who ate cheeseburgers. Okay, and we worry whether that's a big deal or not. The big deal right now is the possibility that there's this warrant, which makes the bond moot in these two cases. But as with all things in Mr. Kendrick's life, it's connected to whatever happened in 2015 because it would be that state probation. Okay?
And that is such bullshit, y'all. The judge even said it. As with all things in Mr. Kendrick's life, it goes back to the situation in 2015. Why do we want to ruin people's lives? Yeah, Raynette, cheeseburger was his example. He just used that as an example, and I thought it was kind of cute. But I don't understand why we want to ruin people's lives this way. Like, and how old was he in 2015? 20? 21? 22? Like, and now here he is a decade later still dealing with this bullshit? I mean, it's just ridiculous.
Mr. Kendrick, do you have any questions for me about what we were discussing? I'll make sure. Good lawyers can explain it all to you, but there's a chance right now, not about the facts of your case, don't tell me I wasn't the guy who did this or that, but about the process we've been discussing.
I pretty much understand everything.
Okay. All right. Well, Ms. Bumpus will explain whatever you don't, and we will reconvene. I don't know that we'll necessarily have to have a full-blown hearing once we clear up this warrant situation. If there is a warrant, then I'm tabling bond on these two cases for now. If there's not a warrant or it's lifted or something, then I'll need to have a little bit of that offline discussion with you, Ms. Bumpus, and Mr. Rao about where Mr. Kendrick would be and how that would be structured, so I can see if I'm
Okay, so it sounds like whenever the warrant is lifted,
comfortable.
He'll get out.
Conditions that would keep.
He'll get out. Oh. Yeah, he does. He does, Raynette. He knows how stupid it is. He's a judge. He's been doing it. Like, we all know. Okay, y'all. This is an exciting time of year because tomorrow is my 20th anniversary of being a mother. AKA my son's 20th birthday. Yes. So, tomorrow's the 20th anniversary of me being a mom. Very excited. I love celebrating that day. I'm excited for my son. He's 20. Like I said earlier, we just picked up his girlfriend from the airport, and so celebrating his birthday. tomorrow. And then, you know, we have Christmas on Wednesday. We have, what else do we have? Oh, day after Christmas, we have shopping, half off. Then we have, no, Shaza, it is not stealing the hype. My son's birthday is the day I became a mom. Do you understand? So, like, cool, glad you were born and shit, but, like, I'm a mom now. I'm not stealing the hype. It's my day. When my daughters or my friends, their kids have birthday, my daughter's friends have birthdays, I always tell the mom, happy anniversary of motherhood. Please. It's very important to celebrate your motherhood anniversary. Thank you guys. I'll let him know everyone says happy birthday. So I'm really looking forward to celebrating his birthday. And then tomorrow, or day after Christmas, I always, and when I say always, I mean 100% of the time, go shopping. They have 50% off, like all the Christmas decor, 60% off. Everything is like half off. All the stuff is shop. So I'm taking the girlfriend and my daughter shopping, and I'm going to teach them about the half off deals. So we're going to do that. And then the day after Christmas, we're going to go to Six Flags. So that's a week from today. So next week, I will not be live streaming because I am going to go to Six Flags. My first time ever being at Six Flags. I'm very excited. So I'm going with my son and his girlfriend and my daughter. And so I will not be here with y'all. Okay? So thank you for joining me today. But I will not see you again until the year 2025. That's crazy. That's so cool. 2025, you guys. How does that feel? Feels crazy. All right, so, see? Val Pal celebrates her kid's birthday. I mean, come on. It's like, this is the day I became a mom. I just feel that it's a good day. I don't know. Hey Tavanda, welcome. Sorry you're about to miss us. We're literally just about to head out, but I will be back on when will I be back? I will be back on the first Friday of the new year. Okay? So everyone, Merry Christmas if you celebrate that. I hope you have a wonderful, excellent Christmas and Happy New Year. And I will see you when we get back in January. All right? So, morning Black Butterfly. I'll try to do like some video footage and stuff from Six Flags, okay? And y'all, my son's girlfriend is tiny. She's 4'9". So we're like, is she gonna be allowed on the rides? I'll let you know if they let her on the rides, all right? Thank you so much for joining me. Happy New Year, a Merry Christmas, Happy birthday, all my Capricorns, and I'll see you next year.